which raised the question of the meaning of the First Amendment. So what was happening in that period of time, from the time of 1791, 1798, all the way to 1919? Well, when we look back at our history and we think about it in terms of free speech, what we see is we see a country and a society not committed to free expression, notwithstanding the language of the First Amendment. We can think about the period immediately before the Civil War and think about the statutes that were very common in the South, which the state statutes very common in the South, in which it was a crime for anybody to do what I'm doing in a bookstore on the street corner, or you joining with your friends and giving a speech that advocated the freedom of slaves. That was a crime in every state in the South. In Virginia, it was a crime that was subjected to imprisonment up to 6 months for simply voicing your view that it was immoral, illegal, unconstitutional, whatever your argument, it didn't make any difference. You were expressing a view which was contrary to official state policy, and if convicted, you went to jail. So why didn't any of those cases get to jail, get to the Supreme Court? Well, because the Supreme Court had said in 1833 that the Bill of Rights, including the First Amendment, had application only to the federal government. It did not apply to the states. And so, in the states, vis-a-vis state restrictions on free speech, your only claim that you had a right to engage in that speech would be based on the state constitution and how that constitution, in fact, had been interpreted by the state courts. And it doesn't take a lot of imagination for you to conclude that the Virginia courts had construed that constitutional provision about free speech in the Virginia Constitution to accept these types of prosecutions that were occurring for people who are arguing that slavery was immoral or unconstitutional. So the court also in 1833 said the amendment, the Bill of Rights, including the First Amendment, have no application to private parties. And so if the bookstore didn't want us here, pretty clearly they could tell us to leave. And that was true in 1833 and is true today. To go onto private property, to go into shopping malls, unless your state has done something that a few states have done, California has done it. They've construed their own state constitution to provide a First Amendment right for people to go onto malls and to leaflet and pass out information and to talk to neighbors and friends about their each of they want to talk to. It's not a right that we have. And so, as more and more of America has become malls, and there's less and less downtown, streets and sidewalks, which have traditionally been places for us to communicate, are being lost, and we don't have a right to go to Walmart or to the big malls to exchange information. That's true today as it was in 1833. So what was happening in the North? It's probably unfair to say that the restrictions on free speech were confined during this period to simply what was happening in the South. What was happening in the years immediately after the Civil War, before and after the Civil War, were the development of parks. Some of you may know the history of the development of parks in the United States. Parks were the work of social reformers who believed that people in big cities needed places, open-air places, to recreate, fresh air. But these same social reformers were very concerned that the parks would be abused and misused. And so it was very common when parks were established for rules to be imposed. Rules were imposed and enforced by the city. They hired park policemen, and it was very common for rules to include no rules about leafleting, no rules about protest, no rules about speaking. So the idea that somehow it was only the South that was making it difficult to talk about issues isn't true. We didn't have the same statutes that the South had in the North, but what we had were restrictions on California, particularly on the use of parks. So if you go back and read the debates about Central Park and look at the rules that were adopted when Central Park came into existence, you'll find very clear, explicit prohibitions with respect to First Amendment activities in the park. So we're now at this point after the Civil War. Congress has enacted and the states ratified the 14th Amendment. That's a provision of the Constitution that, among other things, guarantees due process and due protection of the laws. We entered into then a very long debate, a debate that stretched out some 70 years about the meaning of due process of law. Did the due process clause that became part of the law in 1868, the 14th Amendment, did the framers of that amendment intend to make the provisions contained in the Bill of Rights applicable to the states? Or did they have a narrower vision and purpose for that language that you find in the 14th Amendment? That issue was debated extensively for a long period of time. When I say debated, it came up in cases, and the Supreme Court was very divided. Soon after the 14th Amendment became part of the Constitution, a case came before the Supreme Court. It wasn't a free speech case, but it was a case dealing with just compensation when property is taken by the government, something that you all have a sense of. When the government takes your property, they have to pay you. And because that's a provision in the Bill of Rights. And the issue was, did that provision apply to the states? The case arose in Louisiana. And the Supreme Court was sharply divided on this issue. The Chief Justice of the court at that point, in a 5-4 decision, voted with the dissenters. The dissenters were of the view that what the framers of the 14th Amendment intended was that the protections contained in the Bill of Rights would be applicable to the states. But that decision was decided the other way. The Supreme Court concluded that the 14th Amendment had a narrower meaning, that the framers did not intend to make applicable the Bill of Rights, including the First Amendment, that protects speech, and make that applicable to the states. Our history might have been different. We might have gotten a little earlier start on developing what I'll call our modern view about free speech, had we been able to resolve this issue earlier in our history. It wasn't until 1925 that the Supreme Court held that freedom of speech embedded in the First Amendment is a basic and fundamental right, and it applies to citizens in the states. And therefore, when Pennsylvania seeks to restrict our right to free speech, we have the same claim that would arise if the federal government seeks to restrict our speech under the First Amendment. That wasn't until 1925. But what was happening before 1925? Well, there was then, after the Civil War, a whole tumultuous period. Some of you know more about that than others, but it was a period in which we had a lot of people coming into the country from other countries. We had a growing labor movement. We had a lot of unrest about the proposed involvement of the United States in World War I. The federal government was clearly moving us in the direction of involving us in World War I, but a very significant portion of the population opposed that war, and they sought to express that opposition by doing the things that we take for granted today: in the streets, leafleting, pamphleting, standing on street corners, something that's almost gone now, and expressing their views about involvement in that particular war. Congress responded to that opposition by passing a law which essentially made it a crime to say or do anything that opposed the war effort, anything that basically would be construed to advocate that people not sign up for the draft, or argue that the draft in fact was unconstitutional, even though the draft had never been upheld by the Supreme Court. Any argument that you made about how the war should be funded, that you oppose bonds, but you